I did. What up, beautiful people? What is up, sexy people? How we doing? Welcome to tonight's episode of Nights with NiCCI. We are going a little early. We are trying something just a little different this time. I am super excited to be back with you guys. It's been a minute. And if you are watching me on TikTok, you are watching me live, but you are watching a re-air of something really important, something that I'm really excited about, something that I hope more people will tune into, share the good word. You guys, we are re-airing what is probably one of the most clear examples of my case against Lionsgate, Stars, and P-Valley. As many of you are aware, I'm a turn our song back on in a minute, y'all. But as many of you are aware, I am in the middle of a huge battle against a Goliath. In fact, that is the title of my book, NiCCI versus Goliath, A Fight for Creative Justice. And I think I'm going to add equity to that title too, because equity is something that is super important in our community, and I think that it is underrated. But anyway, I'm going to air a little bit of a commercial. I want to talk you guys through. This is going to be more of an informational. I am going to go live at my regular time tonight, and I will be on camera. But right now, I just wanted to kind of go over this because a lot of people have asked. So if you're one of those people who has wondered, you know, what is going on with my case against Lionsgate, Stars, and P-Valley, if you're one of those people who may be considering getting into law, if you're someone who just wants to know the real deal and tired of the smoke and mirrors and, you know, want to know what's really going on out here, there are a lot of very high profile copyright infringement cases that are happening. There are some that I know about that are coming, y'all. It's a lot of creatives out here that are making the decision to stand up for their intellectual property rights. You guys are going to be shocked and surprised at some of the cases that are going to be coming up in the courts soon. Man, let me tell you, you're going to be very, very surprised. But I want to share just a little bit of information with you guys. I did have an opportunity to visit the Supreme Court. I did have an opportunity to visit the Capitol, United States Capitol, with my sorority, Sigma Gamma Rho Sorority Incorporated. It was a wonderful experience. It was so enlightening, and it showed me that there is so much more that I can do as a creative advocate. One thing this case has done is it has emboldened me to go to where change is really made, which is legislation, right? Where we can talk to our elected officials. And I made lots of great contacts with lots of really incredible elected officials and legislators and really smart people. I'm proud to say many of them are members of Sigma Gamma Rho Sorority Incorporated. With that being said, I just want to share a clip, you guys, of us on the Hill, very short and sweet, and then I'm going to talk a little bit more with y'all about this copyright. Take a look. I'm headed right now to go see Senator Bernie Sanders to talk about women and children's health equity in the Capitol building, y'all. Really exciting. We are going to talk to Senator Bernie Sanders about women's health equity. 332.
This is This is good. Oh, no.
Say it. We are strolling the halls of Congress right now,
Doing that
making a
thing.
difference.
That's it.
Yes, indeed. Poodle power.
You sing?
I do.
Do I know who you are?
You may.
Okay.
Brownstone.
It's good to
Yeah.
see you.
Nice to see you too. Thank
I
you.
love your
All right, y'all. That was really flattering. The fact that I was walking by the Supreme Court and one of the, I believe he was an officer for the court because I was confused. They had something blocked off. But anyway, long story short, I got recognized by an officer of the court. That made my heart sing a little bit. I was like, oh, this might be a good sign. So for those of you who don't know, I'm going to talk y'all through another short little commercial break. Like I said, I'm going to be live tonight for our regular show in about 3 hours at 10:30. But I wanted to just kind of present this because I think it's informative. I think it is one of the better breakdowns. I'm not going to be talking all night. We actually have an AI breakdown of my case, and you guys will have an opportunity to actually see the actual court of appeals reviewing my case with my lawyer and their lawyers, and I included some other cases. But real quick, you guys, this is a
Thank you for tuning in to the season premiere of Worth News, the online platform that brings headlines Worth Media believes are worth sharing. I'm your host, Clarence Mack. I will be joined by expert Helen McDuffie. Together, we will unpack the latest developments in celebrity courtrooms. Over the past few years, America's passion for courtroom dramas has reached a fever pitch. From celebrities in the hot seat to former presidents facing legal fire to billion-dollar corporations battling independent creators. In this episode, we take you inside one of Hollywood's high-stakes legal showdowns, the battle between an entertainment behemoth and an independent writer, producer, singer, and fierce advocate for creative equality.
We'll discuss a case with the Ninth Circuit Court of Appeals, where the plaintiff has filed a petition to rehear N. Banks, which is still pending. Although this case is crucial to the future of copyright law, mainstream media coverage has been surprisingly limited. Our mission at Worth News is to shed light on these pivotal stories that matter to creators, innovators, and everyone who cares about artistic freedom. We are diving into the details of this David versus Goliath legal confrontation, discussing what it could mean for the broader creative community, and exploring why the outcome might shape entertainment for years.
Our platform is designed to help unravel the big stories and hidden dramas in the world of culture, entertainment, and entrepreneurship. On this episode, we're tackling one of the most pivotal and often misunderstood topics in copyright litigation: how the district courts as well as the Ninth Circuit dismisses cases before they get to a trial, sometimes even without expert testimony.
If you've ever wondered why some high-profile lawsuits never see a courtroom showdown, and how courts decide no substantial similarity before a jury is called, this episode is for you. You have to look closely at landmark cases involving Disney, Zindel, Gregorini, Fox, Led Zeppelin.
Why is this such a big deal? Because if you're a creator, an artist, or even just a passionate fan of pop culture, these decisions can shape the entertainment landscape you love and directly impact the culture.
Also, if you're an aspiring lawyer or a legal buff, understanding the Ninth Circuit's extrinsics test for substantial similarity is absolutely critical if you ever plan to practice copyright law.
I've seen some of the most talked about Ninth Circuit rulings where entire lawsuits got tossed out at the earliest possible stage. This case we are about to unpack is shaping up to be a cautionary tale for anyone who thinks inspiration might cross the line into infringement, and a fascinating look at the boundary between protected creative expression and everyday ideas that belong to us all. Our focus is on NiCCI Gilbert Daniels, an accomplished writer, producer, and singer who filed a complaint back in January 2022, alleging that Lionsgate's hit series P-Valley infringed on her stage musical, Soul Kitten's Cabaret. Originally filed in Georgia, NiCCI's case was transferred to Los Angeles, where critics say deep-pocketed corporations often have a distinct advantage over underfunded plaintiffs.
In a series of court maneuvers, NiCCI believes she was denied the ability to use critical evidence, sworn depositions, including 57 side-by-side video comparisons. Ultimately, District Judge Stephen Wilson dismissed her claims for lack of substantial similarity and awarded a hefty six-figure judgment to the defense. Despite mounting legal debts of her own and feeling that discovery was cut short, NiCCI refused to back down. Determined to fight a ruling she believed was unjust, she took her fight to the Ninth Circuit Court of Appeals, where ultimately left her with more questions than answers. Keep in mind, these are allegations and not final legal facts. The facts surrounding this case are available on Pacer or WorthMedia.com.
For those who can't quite understand the legal jargon or expert testimony, or if you're simply wanting an even deeper look, NiCCI shares the raw details in her upcoming book, NiCCI versus Goliath: The Cost of Pursuing Justice, which chronicles her 4-year battle against an entertainment titan. What happened next only made the journey more difficult. Her attorney shared on the morning of the hearing that he was in excruciating pain he believed required hospitalization.
You will notice during the hearing that the attorney could not stand. Despite his illness, NiCCI's attorney pressed forward with the oral argument. The hearing we are about to watch took place on December 5th, 2024, in Pasadena, California, at the Ninth Circuit Court of Appeals.
Counsel, you may have questions. You ready? Oh, you're going to sit from there. Okay, that's fine. No, that's fine.
I cannot hear you speaking, sir, so if you'll pull that microphone to you, that would be great.
It looks like it was off. Can you hear me now?
Yes, I can. Thank you so much.
We represent the plaintiff in this case. She is the author of a play, Soul Kittens Cabaret, otherwise known as SKC. It is a registered copyright along with the filming of the play we call the DVD that was filmed of the actual performance of the play, both of which are registered copyrights. We allege in this case that the defendants wrote and produced the television show P-Valley, which is at every single elementary level of the Ninth Circuit substantial similarity test, basically a rip-off of plaintiff's work.
First, my biggest question is that it seems to me that the themes that you identify as being substantially similar, such as the morality issues, good versus bad, choices that people make as mothers, daughters, partners, that those are things that flow pretty naturally from the setting of these two works and are unprotectable. So if you could address that, that would be helpful.
Our expert, Mr. Rodaft, is, as the district court noted, no doubt extensively experienced in reading thousands of scripts. That's what he does. He reviewed a lot of the films, most of the films in this, let's call it a niche subgenre, and he was able to do exactly what you say, to separate what is and what is not protectable. But even over and above that, there's an important analysis, the selection arrangement test, otherwise known as the Metcalf test.
In Metcalf versus Bochco, the Ninth Circuit recognized that even if individual story elements or ideas like stock characters, settings, or themes are not protectable on their own, the unique way those elements are selected, arranged, and combined can be protectable. In simpler terms, if you take everyday pieces but arrange them in a special, distinctive way, that overall combination might be protected even if each piece, by itself, is not.
So the key takeaway of the Metcalf test for substantial similarity is that courts must look beyond individual or unprotectable elements to see if the creator's specific selection and arrangement rises to the level of protectable expression.
Yes, this is a Ninth Circuit precedent, so this should have been considered in the light most favorable to the plaintiff. But let's continue watching.
I'd like to talk about the Metcalf test briefly because there's this insinuation from the district court that it is either a dying doctor or something that's hyper narrow. The district court gave, I think, short shrift to the Metcalf test only to say these are the issues or these are the facts that were at issue in Metcalf. And a conclusory statement with no analysis to say our facts don't come anywhere near to meeting the similarities in Metcalf at the selection arrangement test. First of all, the two most recent cases in the Ninth Circuit that address Metcalf are an endorsement of Metcalf. You've got the Alfred case, the Pirates of the Caribbean case, and there the court, the Ninth Circuit, stated that an expert might indeed be helpful in separating what might be a mere pirate trope from the rest of the film.
Oh, was that a motion to dismiss stage?
It wasn't a motion to dismiss stage, but nevertheless, it talked about the importance of why expert testimony might be important. It was Judge Page that wrote that opinion, I believe you read from, Your Honor, and it was, that's one where, at the oral argument, he quizzed the appellant and asked, does this mean that we're going to have an expert in every case? And the appellant in that case said, no, but you do in this one.
Senior Judge Pius of the Ninth Circuit Court of Appeals has consistently emphasized the importance of expert testimony in legal proceedings, particularly in complex cases. He advocates for a thorough and fair evaluation of such testimony, cautioning against its unwarranted exclusion.
That a lot of the elements we're talking about here are unprotectable elements that are sort of generic to pirate stories. You have
how do we know
pirates who like
Miss Lloyd, how do we know what's generic to pirate movies?
Well, I think that in this
I can't say that I'm schooled in the history and lore of pirateerism or whatever you want to call it, whatever it might be called. How do you know? How do you know what's generic or scenes l'affaire? Scenes affair. How does one know that? So you can say, as a matter of law, there is no infringement here. I mean, that's what I have a hard time figuring out.
I understand that, Your Honor. Only in their appellate brief are they saying that an expert could give them more arguments to make, but framing what they see as the similarities in this case. It's not going to change the works. It's going to give them another opportunity to make arguments about what they see as similar. And that there's no need to grant.
I understand our case law allows us to say on a 12b6 that as a matter of law, there is no substantial similarity. I understand our case law says that. And you look at Rentmeister, the photo of,
yes.
That's a very classic example of that taking place. But nonetheless, it does seem that you got to be very careful when you do that. You got to be sure. Because what you're saying is there's no plausible claim. There's no plausible basis for the alleged infringement on a 12b6. And it seems to me that determination would be easier on summary judgment, because on summary judgment, you can actually take a look at everything, and then you can say no reasonable trier of fact could conclude that there would be infringement, which from my perspective as a judge, I even find that in some instances to be a difficult call.
Judge Pius also highlighted that challenges to the reliability of expert testimony should typically be addressed through cross-examination during trial rather than outright exclusion. He emphasized that excluding expert reports in their entirety, especially when they offer relevant opinions with sufficient foundation, exceeds the court's limited gatekeeping function.
Judge Paez's perspective strongly supports the admissibility of expert testimony when it is grounded in appropriate methodology and relevance, favoring in-depth examination during trial over preemptive exclusion. In the case of Skidmore versus Led Zeppelin, Judge Paez addressed the role of expert testimony in copyright infringement disputes. He emphasized that the extrinsic test requires analytical dissection of a work and expert testimony, highlighting the necessity of expert analysis in determining substantial similarity between works.
Judge Pius further noted that the district court abused its discretion by not allowing recordings of Taurus to be played for the purpose of demonstrating access, underscoring the importance of considering all relevant evidence, including expert testimony, in such cases.
So, I have a question here, because we are examining the exclusion of the expert for abuse of discretion, correct?
Yes, that's the statement.
And there are cases such as Rice, which have upheld the exclusion of expert testimony, particularly where, as in this case, it basically restates the things that were already offered by your client.
Rice versus Fox. Magician Robert Rice sued Fox Broadcasting, claiming their TV special revealing magic copied his copyrighted video, The Mystery Magician. To strengthen his case, Rice relied on an expert who argued that both works were similar because they featured a masked magician revealing tricks. However, the judge threw out the expert's report, saying it didn't prove the character or tricks were unique enough to be protected by copyright. Rice's case fell apart without this critical expert testimony, as the court ruled that generic elements like a magician in standard attire performing common tricks couldn't be copyrighted. This decision hurt Rice's claim significantly and ended the case in Fox's favor. Once again, you have a well-funded corporation winning a court battle over an underfunded plaintiff, and most expert reports can run into the tens of thousands, so throwing them out doesn't seem fair.
This oral hearing highlights the inconsistent treatment of expert testimony in copyright cases. The panel's reliance on Rice versus Fox contrasts with the Ninth Circuit's en-banc decision in Skidmore, which stressed the importance of evaluating expert analysis. Rehearing en-banc can establish uniform guidance on the admissibility and role of experts in substantial similarity cases. The case could offer an opportunity to create uniformity because it sounds like Judge Graber is convinced that the same thing that happened in Rice should happen in this case. But let's keep listening.
In this case, it basically restates the things that were already offered by your client. And I guess I would appreciate your directly addressing Judge Thomas's question about why some of these tropes are not too generic to be protectable.
Sure. Okay, so first of all, the abuse of discretion standard is indeed the applicable standard here. There remains, even post the amendment to Article 702, a liberal thrust towards admissibility. The expert in this case opined that he had studied extensively this genre so that he could separate what might otherwise be perceived as sans-affaire from everything else. Moreover, the expert report goes in to address Judge Thomas's question, goes to address the chronology of all the scenes. The police will charge that this is just a shotgun approach to a bunch of similarities scattered throughout. It's not the case. Our expert talked about, importantly, that this was in a chronological order, similarity at every one of the relevant elements under the Ninth Circuit's substantial similarity test.
Just to follow up on what my colleagues are saying, there's something that naturally follows from chronology as well. If a dancer is going to show up at a city as an ingenue, and then there's a character arc to that, you would expect the arrival first. As you were trying to point out, you're briefing a beginning, a middle, and an end. But if it's at a high level of generality, how does that start to fit into a Metcalf framework where it's very highly specific details that seem to be more of a rip-off as you were describing earlier?
So I would argue that we both meet the test of the regular substantial similarity in addition to the Metcalf test. It's not like Metcalf is just a backup here.
After watching the 57 comparisons, I wondered whether a reasonable juror could examine the following list and decide whether it is close enough to the same order and arrangement to pass the Metcalf test. Remember that each description occurs at the beginning, middle, and end of both, and almost the same order, despite one being a 2-hour stage play and the other an 8-episode TV series. In the beginning of both shows, a lean, wiry, shy, new girl carrying a vintage red suitcase arrives by public transportation. She checks into a seedy motel and needs to find work, so she heads to an erotic dance club to audition for talent night. The new girl is a mediocre dancer but hired on the spot. She is not dressed appropriately. The gender-fluid owner points her to a rack, where another employee hands her a skimpy outfit. The modest erotic dancer changes in the bathroom. Other dancers taunt her. The new girl keeps a secret life back home and doesn't disclose her true self initially. The owner is looking for a replacement for a veteran dancer who will no longer work at the club. The owner, who usually dresses as a woman, dresses as a man for a very important business meeting discussing his club's fate. The owner is taunted by the person he is meeting about how he dressed like a woman the last time they met.
Fabulous Tata burlesque. All dressed up like a man for the occasion. Oh, I see. You got on a little cheap suit, so today you think you a man.
The owner then tells the staff that things must change to keep the business afloat and explains that he is cracking down on employees. An employee lies about why she is late, but the owner comforts her instead of firing her. Love at first sight between a handsome young bartender and starlet as they bond over grandparents in the stockroom. The owner learns antagonist is plotting a takeover of the building so he can have the valuable land for casino development. The following descriptions occur in the middle of both SKC and P Valley. The owner is verbally assaulted and called a he-she freak by antagonist due to his lifestyle choices. The owner has had to endure homophobia and down-low relationships all his life. The antagonist hires an inside man to help with the club casino takeover. The inside man is reluctant and falls in love with club employee. Each dancer goes through individual crisis fighting poverty while caring for young children. A dancer L decides to leave the club to open a new business. A dancer attends church, paying tithes to heal from demons created by strained relationships with religious parents. New lovers fall out of love because of a gun incident. The owner brings the staff together in a huddle to announce the closing and last night at the club. The owner tells each employee how important they have been to the club. The owner reminds them that this is not the end, but the new beginning. The mood is somber yet positive. The following list of descriptions occurs at the end of both Soul Kittens Cabaret and P-Valley. The ex-husband of one of the dancers comes to the club and grabs a co-worker by the neck. Gunfire ensues, and everyone thinks the owner was hit. People dress up for a funeral, but instead of a funeral for the owner, it's for the closing of the club. The entire staff and community are present. The antagonist shows up wearing a fedora and carrying a flask to taunt the owner and his employees after they lost the club. A female employee that no one liked was working undercover and saved the day, ends up owning the club. They celebrate that the owner can continue his business of running an erotic club. As an ordinary observer, I see enough in this list of similarities to go to trial.
The similarities here are not just so common that every one of them necessarily flows. Let me give you a couple of examples. There is, and I want to further address in this example how the district court erred in not honoring the rule that the tie ball goes to the non-movement on summary judgment in cases of substantial similarity. In this case, wherever there was an opportunity for him to draw an inference in favor of the non-movement, not only did he choose between A and B, he found a C. Okay.
The law says these decisions are supposed to be left to a jury, also known as an ordinary observer, but even with these images, videos, the expert, even witnesses to access Lionsgate may have had to the plaintiff's materials. The courts didn't seem to view this in the light most favorable to the non-movement.
The comparisons do suggest there may be a genuine issue of fact that warrants jury deliberation. If courts dismiss these cases based on technicalities or narrow interpretations of protectable elements, it can feel like the bar for infringement is set so high that meaningful disputes never make it to a jury. This dynamic underscores ongoing debates about fairness and accessibility in copyright litigation. But we aren't the judges, so let's continue to watch and unpack their decision.
So, for example, we highlighted three points in our brief. I'll give you a bonus one here in our argument. And there is, we have in both works, the owner of the club is an African-American LGBTQ person. There's four or five core dancers, one of whom is a queen bee, and we have the newbie dancer arriving. It's established that this newbie dancer comes to the club carrying nothing but a red vintage suitcase. She's shy about her body. She gets the job. There is the owner of the club is fending off closure from the local casino. They could have chosen anything other than a casino, but that's the issue that was involved in both works. Judge Wilson here gives short shrift to the casino element in our work, P-Valley, saying it was only a minor element. Our expert refutes that. He says, no, the casino element is indeed an important plot arc. And I'm not sure where.
Well, why, counsel? And this goes back to what's being repeated by the expert versus your arguments, but the casino development plot point in P-Valley runs through the entire first season. It seems to be a fleeting reference, and it was difficult to surmise where it came from because it wasn't very clear in the briefing. But it seems to be just a passing reference in the play and in the movie. How does it figure prominently in your view in SKC?
Because it is a prominent bond in SKC. The takeover is not minor. And perhaps if you just control F for the word casino in SKC and see it a couple of times, you think it's a minor plot line. And I think the district court, frankly, just adopted the contention of the appellees. But if you were to actually study both works, actually watch all of SKC, you'll see that it is indeed a major plot line. But that's, again, another example of how the court just didn't draw the inference to the non-movement.
But how many times did the casino, how many times was it referenced?
I couldn't tell you
So you're here trying to dispute that there are no tribal issues of fact. So your contention is that this is a major plot point. So can you back it up with some references to the record?
At the moment, not specifically. I could just tell you that it is woven throughout the entire thing. It is not fleeting reference.
When a stage play briefly references a casino plot perhaps only once or twice, it may seem like a minor detail on the surface. However, in the focused world of theater, even fleeting mentions hold weight, driving the story forward by hinting at themes or issues that unfold within the core dramatic framework. Unlike a TV series, a play has limited time and space, so its storytelling centers on a specific conflict or a small set of characters. As a result, the play may reserve only a few precious lines to highlight the casino storyline, weaving it subtly into the plot without diverting attention away from the main action on stage. In contrast, an episodic television adaptation can explore that same casino premise in far greater detail, turning a single mention into an entire subplot or even multiple episodes. In Soul Kitten's Cabaret, the casino plot was established at the beginning of the play, and it drives the action and intention of the antagonist. His entire role in the story motivated by the casino development. As evidenced in the following clip, the contentious meeting between Tata and Frank establishes the casino plot from the beginning of the play and is the antagonist's driving force.
I know why you want this place so bad, Frank Jr. I know about the casinos they're trying to build, and I know how much money this land is worth.
A derivative work made into a dramatic TV series like the one NiCCI allegedly pitched to Lionsgate would definitely mention the casino multiple times throughout the season.
And how else did the district court sort of look at this when you tried to decide against your claim?
Sure. So, for example, the LGBTQ African American club owner, the district court gives a lot of skepticism to that similarity, saying that, well, one is non-binary and one is gender fluid. And are those differences important? Yes, in general. But for purposes of what we're talking about here, substantial similarity, that's not what we should be talking about. When the district court chides us by saying that when we allege that a nude dancer arrives by a taxi cab in P Valley, in SKC, and a bus in P Valley, the district court says, well, you're mischaracterizing the evidence because that's not public transportation. Your Honors, I would submit to you that if we're quibbling about the definition of what is not public transportation, that is not what the district court is supposed to do.
Before your time is up, I would like you to address what I see as a problem for your side of the case, and I'd like to hear your response to it. To me, the themes, the dialogue, the mood, the setting, and the pace could not be more different between your client's protected work and P Valley, which is dark and violent and all about domestic violence and the place of religion and a bunch of things that have nothing to do with SKC.
The expert's report is essential because, in this situation, it could offer some insight into the judge's question about P Valley being darker than SKC. I wouldn't consider a story about an erotic dance club in a bankrupt inner city at risk of being taken over by a casino staffed by women who can barely take care of their children, one of whom was the product of SA, a lighthearted story.
So, just taking a step back, why are these sort of what I view as smaller things sufficient to overcome those huge dissimilarities?
I would disagree that they are so strikingly different. I think perhaps the opinion of Judge Wilson says that, but this is, again, where the judge...
We have de novo review, but I'm asking you why my view is wrong.
Sure. Well, I'm going to get into the expert opinion, which, again, is not a rubber stamp of just what our client says. They give extensive examples of what is similar. You pointed out religion is the same. Religion is not an important component of P Valley. That's in the district court's opinion. But then again, that's an inconsistency because in the opinion itself, in the very next sentence after the district court says that religion is not an important feature in SKC, it goes on to say that religion is indeed a feature in SKC. It is internally inconsistent.
You don't have to quote the Bible scriptures to me, okay? My mother did that for 18 years of my life. And it keep her from tearing me down every chance she got.
As you'll see in the following clips, Soul Kitten's Cabaret has themes of addiction, domestic violence, mental wellness, and even gun violence.
Your $2 hoe just went up to $2 million.
You trying to make a fool out of me?
No, I'm not.
You trying to take everything I work for?
No, I'm not. Please. Let that baby go.
There are limitations because we watch the action play out on a stage versus a TV series, where lighting can be more dramatic and stylized.
Let me give you one more example. This signifies the district court's error, okay? There's a scene where the newbie dancer goes to change in the restroom at the beginning of her career in this strip club movie. Changing in the restroom in this kind of modest context is a little bizarre, right? Because it is a strip club. They're in the back with all the girls, okay? The district court does two things. One, he disagrees with our characterization that the character in SKC changed in the bathroom, notwithstanding the fact that in the record there is, quote, I'm a little bit shy about my body. Can you show me where the bathroom is? So, of course, she's changing in the bathroom in SKC. Then in P-Valley, the district court goes on to say she changed in the bathroom not because she was modest, but because she had to hide a gun and put down a bottle of alcohol. By the way, the bottle of alcohol was a miniature. She took 2 sips of it. But in the play, we see in P-Valley, one of the other dancers says, she's been here a week. What has she got to be ashamed about? Of course, modesty is the issue for both characters in that scene. Yet the district court, instead of choosing between A and B, he went out of his way to find C, a different interpretation, a preconceived notion that these things are dissimilar, which is not supposed to be focused. He's supposed to be focusing on what we allege are the similarities, taking as true our allegations, and did not give, on summary judgment, a non-movement, the inference that we deserve.
You're ready to your bones out of receive my colleagues. Any other questions? Okay. We'll give you a little bit of extra time for a battle. Thank you.
I have to say, despite the plaintiff's counsel being in excruciating pain, he did a great job of sticking to the facts and bringing it back to the expert report, and how the district court abused its discretion by striking the expert and not considering the evidence in the light most favorable to the non-movement.
Good morning, Your Honors. May it please the Court, my name is David Halberstatter, and I'm appearing on behalf of the appellees. Your Honor, just because appellant and appellees disagree about the accuracy, the validity, or the significance of appellant's comparisons of the works does not mean a material factual dispute over substantial similarity exists. In fact, if that were the case, summary judgment would never be appropriate on substantial similarity grounds because the adverse parties always disagree about the claims of similarities. Rather, it's the works themselves that control, not what the parties say about those works. And it is the objective evaluation of the works using the extrinsic test that determines whether a reasonable jury could or could not find the works to be substantially similar in protected expression. The district court engaged in that objective evaluation. It reviewed the works. It carefully identified the elements of plot, theme, dialogue, mood, setting, pace, and characters that were unprotectable. It filtered those elements out of the analysis. The district court then compared what was left, the unprotectable expression in the works. The court found that a number of the 57 purported similarities that appellant identified were actually not based on any of the 3 Soul Kitten's Cabaret works that were in issue. By appellee's count, there were at least 10 of those. The district court found that a significant number of the remaining similarities were the result of appellant's mischaracterizations of one work or the other, or both. By our count, there were at least 10 or 11 of those as well.
This statement by the defense could be considered mischaracterization. The materials referenced in the appellant's comparisons were included in the declaration of facts submitted to the court. The assertion that they were not properly cited or included is factually inaccurate. Copyright protection attaches to a work automatically upon its creation and fixation in a tangible medium of expression. The Copyright Office registration is not required for the work to be protected. Registration of materials with the Writers Guild is evidence of authorship and creation date, which can be used to establish copyright ownership in court.
The district court then found that upon it made still other alleged similarities seem similar by taking particular elements out of context and describing them generically when the actual expression was markedly different. Based upon its extensive and thorough analysis, the district court concluded that no reasonable jury could find substantial similarity between the work's respective plots, themes, dialogue, mood, setting, pace, and the characters.
It would be helpful if you could address for me the issue of the expert declaration and why the expert's career, his 30-year career, was not sufficient to qualify him as an expert.
Certainly. Well, to answer that narrow, specific question, there are a lot of people in the entertainment industry who read scripts as part of their job. And if they've had a career as long as this expert has, they've probably read thousands too. But that doesn't qualify an individual to opine on substantial similarity if they don't have any background in literary analysis, literary criticism, or even as part of their job comparing works for this specific purpose.
We're talking about literary works here where, obviously we have script to movie. In this case, in Esther White, we had treatment to television series that had gone on for years. And
Your Honor,
I think it's kind of hubris for a district court judge to think they have enough knowledge and basis in film and theory, things that people go to school for, USC, UCLA, to learn all about, that they can just decide this on just a dismissal stage. Except, I think, in rare cases where it's just obviously so frivolous. And that...
Is there a case that says that an expertise in literary analysis and criticism is a prerequisite for this type of expertise? Well, I would say, Your Honor, that this judge, Judge Wilson in Gable, reached that conclusion in striking the expert testimony of Professor David Demmer, who was a well-recognized scholar in copyright but had no expertise in literary analysis, and this court affirmed that exclusion. So I don't know that there are any other cases that would support this, but you're relying on the abuse of discretion standard. Yes, very much so.
The abuse of discretion standard is a legal principle used by appellate courts to review decisions made by lower courts, judges, or administrative agencies. It evaluates whether the decision was unreasonable, arbitrary, or based on legal or factual errors. A decision constitutes an abuse of discretion if 1. It relies on incorrect legal principles. 2. It is based on clearly erroneous facts. 3. It is unreasonable or outside the range of acceptable choices.
This standard is highly deferential, meaning appellate courts are reluctant to overturn decisions unless there is a significant departure from proper reasoning or fairness. It is commonly applied in reviewing evidentiary rulings, sentencing, or administrative actions.
In fact, as this court knows, expert determinations lie peculiarly within the sound discretion of the trial court, and reviewing courts afford the trial court a high degree of deference. So for this court to overturn the granting of the motion to strike, it has to be firmly convinced that the district court decision lies beyond the pale of reasonable justification.
Yes, as counsel pointed out, that expert opinion can be helpful in letting courts sift through an objective test. Why is it useful in some circumstances versus this? Why was this not one of those instances?
Well, first of all, instances in which an expert witness on prior art, for example, could be relevant. is if there is a significant body of pre-existing works that employ similar elements of expression and so forth, then an expert who is fully knowledgeable in that prior art, not someone like Mr. Aft, who watched 3 other films. Someone who is knowledgeable in that prior art might be useful in identifying factors that might otherwise on their face seem to be protectable expression, but which are in fact common tropes for a genre. But that's not.
If a judge can't do a comparison on the paper that he or she has, then, and because there has to be expert testimony, then it's kind of a nice way of saying all these cases are going to have to go to trial.
Well, not necessarily, although we think this case should go to trial, because on summary judgment, we can bring in evidence of experts, and we can at least hope that the district court will consider. In this case, the district judge made the decision, much as in Astor White, as you will read the concurrence says, without even an argument by the lawyers. So the judge doesn't simply decide the facts, and this is a fact question. Substantial similarity is a fact question on this court's law. And the judge decides the case, doesn't hear from experts, doesn't want to hear from jurors, doesn't even want to hear from the lawyers. Just simply makes a decision in chambers about something that's as sensitive and delicate as literary equivalence.
What rule? I mean, we don't. So it's only recently that we have this situation with district court judges sitting in their chambers with no expertise or knowledge of the film industry whatsoever, not even having the benefit of argument from counsel, and deciding things on a 12b6 motion when the standard is plausibility. Should we develop a rule that simply should not occur? We should prohibit dismissals based on substantial similarity under those circumstances? I mean, there has to be. I mean, I look at this case and I look, at Astor White, and there must be some cases that are just so frivolous that they deserve to be dismissed at the 12b6 stage for failure to plausibly state a claim. But then there's others where it begins to get grayer. And I'm just seeing district courts just disposing of cases on the easiest ground available. And I think it's troubling me, but I don't know what rule is the right rule to have. I mean, Nimmer says, and I've always agreed, that even on grants of summary judgment should be extremely rare in this kind of a case. So grants of summary judgment are, a much higher standard that you have to meet than just plausibly stating a claim. That aspect of this case, counsel, really troubles me. I do not want to encourage district court judges to do this.
That's not the case.
If we were to disagree with you about the ruling concerning the plaintiff's expert, what would be the result of that? Would we have to remand, or would we simply consider the expert's declaration as part of our de novo analysis of substantial similarity?
Thank you, Your Honor. I do not believe that first of all, let me say that before responding to that question, and I will, it does not matter whether any of the members of this panel, had they been sitting at the district court level, would have ruled differently. That's not the test. The test is whether or not the judge...
My question is a different question. I want you to assume, for the sake of my question, that we think the district court was wrong. Then
I do not believe it would be necessary to remand. I think this court, reviewing the record de novo, has the report as part of the record, and it could review the report and accord it what weight this panel thinks it is due.
The combination of unprotected elements could be protected in combination.
But if we look at what the plaintiff's expert testified to, he testified to a similarity in the fact that there were cords that were broken. He admitted, and our expert showed, and the
He may have been the worst expert in the world, but he did testify that that Led Zeppelin's song infringed the deposit copy, did he not?
He was comparing it to the deposit copy. On the motion for summary judgment, he compared it to the studio recording.
Right, but at trial, which is what we don't care about denied motions for summary judgment, we don't review them.
Right.
At trial, he testified that it infringed the deposit copy. He may have been the least believable expert in the world. He may have, but we can't reject his testimony because he was impeached, can we? Isn't that for the jury?
I would add that I don't believe had the district court considered the expert report that it would have changed anything because the expert largely parroted appellant's comparisons, which the district court found repeatedly to mischaracterize the works.
It is entirely possible for an expert to arrive at the same conclusion as the plaintiff's allegations. The key distinction lies in the use of the Daubert methodology and extrinsic analysis. Inferences from the facts are jury functions, not those of a judge ruling on a motion for summary judgment. Striking the expert report and dismissing the case improperly encroached on the jury's role. The court's role is limited to determining whether there is a genuine issue of material fact for trial. It is not the court's role to assess the credibility or persuasiveness of evidence, including expert testimony. Determinations about the weight or credibility of evidence, including whether an expert's testimony is parroting or lacks originality, fall squarely within the jury's domain. Even if the expert's report appears weak or derivative, it should be for the jury to decide its credibility and impact.
Striking the expert report for parroting improperly required the court to assess the credibility and substance of the expert's conclusions, a function reserved for the jury. Even if the expert report was not compelling, it could still have raised a genuine issue of material fact sufficient to survive summary judgment. The court should have allowed the jury to weigh the expert's testimony against the other evidence, rather than preemptively dismissing it.
Have I answered your Honor's question?
Yes, thank you.
Thank you. So, there are a couple of things that I wish to stress. Well, first, the similarities that appellant alleged existed between her Soul Kidness Cabaret works and appellee's television series P-Valley, in my view, were even less compelling than those in the seminal Ninth Circuit decisions in which this court affirmed summary judgment for the defendant appellee on substantial similarity grounds, without, may I add, any expert testimony. Those other cases include Litchfield versus Spielberg, Burkitch versus Crichton, Karth versus Walt Disney, Funky Films versus Time Warner, Benet versus Warner Brothers, and Gable versus National Broadcasting Company, and many others. In all of those cases, the court reviewed the works themselves, just as the district court had done. And without expert testimony, it consistently found, just as the district court found in this case, that many of the comparisons made in those cases involved unprotectable ideas, stock elements, stock characters, that the claimed similarities mischaracterized one or the other of the works, such as the works were not actually similar in their protected expression, and that any remaining elements were nothing more than random similarities scattered throughout the works and were a different expression of common unprotected ideas and themes. In my view, the significance of appellant's completely false comparisons cannot be understated. Appellants pointed out in their answering brief that at least 10 of appellants claimed the similarities between SKC and P-Valley were not based on SKC. Rather, they were based on a different work by the appellant, a TV pilot script called Curtains, which may have been based upon Soul Kidness Cabaret, but it is not a registered work and it was not a subject of appellant's infringement claims.
The defense attorney's statement that some materials were not copyrighted is legally incorrect. As soon as appellant fixed the materials in a tangible form, they were protected under federal law.
Correct. And by dismissing comparisons based on an erroneous assumption about copyright status, the panel improperly filtered out evidence that should have been considered in the substantial similarity analysis. Filtering out evidence of similarities based on an incorrect assumption undermines this principle and deprives appellant of a fair adjudication. In this case, appellant's declaration states she left copyrighted materials with the CEO of Lionsgate, creating a specific channel of communication. The CEO having a lack of recall is not a denial of access, but a factual dispute appropriate for jury resolution.
They did it again today by referencing the scene in which the dancer arrives by public transportation. The public transportation element is not present in any of the SKC works that are at issue. It was included in the curtains script, but not in the scripts at issue. There's no question or dispute about this. Plaintiff's own comparison video clearly shows the source of these 10 purported similarities as being from curtains. But appellant did not withdraw these claimed similarities on appeal, rather she just doubled down. Likewise, the significance of appellant's blatant mischaracterizations of the works also cannot be understated. Throughout its order, the district court identified comparisons that mischaracterized one work or the other in order to manufacture a similarity. And even when it didn't call out the appellant expressly, it was implicit in the court's repeated findings that one element or another was expressed differently as between the works, and that, such that appellant's comparisons were actually disingenuous. And they're doing it again today.
Something that I find interesting as I watch NiCCI Gilbert's case against Lionsgate is how substantially similar the defendants in the argument are to the defendants in other cases, like Zindel versus Disney. Take a look.
The only thing that these works have in common is that it's a cleaning lady bonding with an animal who she attempts to have escape. What happened here, what the district court did, and I definitely want to discuss, Judge Wardlaw, your concerns with motion to dismiss.
Well, I understand that the defendants in these cases, the people who you're representing, the institutions, the producers, the creators, they want to get rid of these things immediately. I practice enough in this area that I completely understand, but I do worry about the situation, and we don't have a published opinion. All the history of the Ninth Circuit, we do not have a published opinion affirming a dismissal at Rule 12b6 stage on substantial similarity grounds. And I would say it should be limited to the most frivolous of cases, because the standard at the Rule 12b6 stage is plausibility.
That doesn't mean, plausibility does not mean the most possible frivolous case.
No,
it means
it doesn't,
exactly
but have
that.
they
It must be
plausibly
plausible.
stated a claim? And if you're looking at a script and a movie, I don't know, I mean, under what circumstances could you say that they had not plausibly treated a claim?
Yes, this counsel, in terms of the comparison of Tata Burlesque from SKC and Uncle Clifford from P-Valley, there's a dispute between the sides as to whether gender fluidity versus a gay male character is a notable distinction or could be grouped together. Can you speak a little bit to that point? Well, sure. I would, I'm not in either category, but I imagine that if I were a gay man, I would consider gender fluidity different. And similarly, if I were a gender fluid individual, I would probably react to being characterized as a gay man.
Counsel, there's also the distinction in the way these are expressed in terms of their identities. I mean, Tata doesn't have, long silver nails and some of the other things that occur with Uncle Clifford.
Yes, that's correct. Uncle Clifford identifies as female. He wears predominantly female clothing. I believe there may be one scene when he was going to a bank where he took off his nails and dressed as a male. Uncle Clifford uses exclusively feminine pronouns. Tata Burlesque, by contrast, dresses like a male, refers to himself with male pronouns, and is an entirely different character.
Okay. I'm sorry, Mr. McVale or Miss Burlesque. I just get a little confused sometimes because don't you dress up like a woman sometimes?
In her upcoming book, Nicci vs. Goliath, The Cost of Justice, Nicci addresses the distinction between Tata Burlesque and Uncle Clifford. Nicci says, and I quote, "The court took it upon itself to judge the nuances of representation, love, and gender identity as a matter of law. The intimate, interpersonal relationships between two people in the LGBTQIA community are both complex and deeply nuanced, defying attempts to fit them neatly into predefined categories. This complexity is reflected in the LGBTQIA acronym, which encompasses a broad spectrum of identities and experiences. It is not a definitive explanation of what love and gender identity are, but rather a testament to the diversity of human connection. For the judges in my case to take it upon themselves to determine that substantial similarity did not exist between my character Tata, which is French for anti-burlesque, and Uncle Clifford from P-Valley, by deciding, as a matter of law, that the distinctions boiled down to superficial details like nail length, hair color, or the amount of makeup and liquid liner worn, was a gross oversimplification of complex narratives. Their ruling failed to account for the layered originality and depth of the characters and dismissed the lived realities that these characters sought to amplify.
Have I answered your question? You did. I mean, really what I'm thinking about is what level of specificity would we need to get to in this context, for example, because there aren't that many stories about an LGBTQ related owner of a cabaret or nightclub. And so we can slice it further down, and I take your point that there are these differences, but is that necessary for the sufficiently similar analysis? No, it is not necessary because there are many other differences, including how each of those characters came to own the club, how those characters could potentially lose their club, how those characters interact with the dancers at the club, how that character interacts with the antagonist, and so forth. So there are so many differences in the expression of each of those characters and what they do and their role in the story that you don't really have to parse that piece out. Correct.
Both Tata Burlesque and Uncle Clifford occupy spaces that highlight the intricate dynamics of being openly queer while navigating relationships with men who prefer to remain on the down low. These relationships are fraught with societal pressures, stigma, and secrecy, creating a narrative ripe for exploration. In my work, Tata's down low lover profoundly shapes Tata's arc, while in P-Valley, Uncle Clifford's relationship with a closeted man is ongoing and central to the plot. These differences in resolution are not a matter of whether one is more gay or authentic than the other. They are creative choices that reflect the spectrum of experiences within LGBTQIA communities. Reducing these rich narratives to questions of nail length or hair color erases the cultural and emotional weight of the characters they represent. It is an act of legal dissection that prioritizes dissimilarities over thematic resonance and shared humanity. Worse, it establishes a precedent where courts armed with limited understanding and lacking professional expertise in gender studies or queer representation may feel empowered to decide what qualifies as gay enough. Tata Burlesque and Uncle Clifford are not simply archetypes of queer representation, they are embodiments of resilience and resistance against marginalization. Both characters navigate spaces where their identities are simultaneously celebrated and scrutinized. They act as protectors and nurturers within their communities while grappling with the complexities of their personal lives. By denying the depth and intricacy of these characters, the court failed me in the underserved communities my work sought to amplify. The fact that both men are black, gay, run an erotic club that caters to straight men makes them both rare and substantially similar.
I want to take a moment to address the casino element in these cases and how much of a driver it is in the relative ones.
Yes, I'm happy to. And Your Honor asked opposing counsel a question about how many times it was referenced in Soul Kitten's Cabaret, and I don't remember it for sure, but I think it was twice. And it may have only been twice in one of the works and not in either of the other two. It was not a plot element at all. Further, the character who they're attributing to whom they're attributing this casino plot development, Frank, is the deceased lover of Tata Burlesque, who gave the club in his will to Tata Burlesque, and it is apparent far, far more so in all of the three Soul Kitten Cabaret works that he is driven by animus. He thinks that Tata Burlesque bewitched his father, turned him gay. I use turned in air quotes, turned him gay, and he thinks he is the rightful owner of the club. So he wants to do anything he can to get that club back. It has nothing to do with a casino development.
I know why you want this place so bad, Frank Jr. I know about the casinos they're trying to build.
This casino want to buy our land.
And I know how much money this land is worth.
You bringing the casino here shows me you remembering your peoples.
No, sir. I'm no snitch. Come on, love. Come on. Look, I can get you up to $1 million.
$6 million, like we discussed.
I answered your question. Thank you. Great. So, the other item, so as I mentioned, Appellant has doubled down on these mischaracterizations and did it just now in his oral argument. Appellant's counsel focused on the shyness, reported shyness of the new girls in each work by focusing in P-Valley on what the other dancers perceived Autumn to be doing while she was changing in the bathroom. She was not changing in the bathroom because she was shy. She was changing in the bathroom because she was checking her weapon and having some alcohol.
1 week later, and this bitch still changing in the styles? Like, what she got to be shamed about?
The other dancers obviously didn't know that because she was changing in the bathroom. And so they wondered why, how could she be, ashamed of her body at this stage? But it's not the same as Brandy in Soul Kitten's Cabaret, who was genuinely shy about her body and was changing in the bathroom because she was shy about it. That was a perfect example of how Appellant had mischaracterized one work or the other to make them seem similar when they were not.
It is crucial in copyright infringement cases, especially when evaluating substantial similarity between characters, that judges and attorneys do not unilaterally decide whether a writer's characters have been mischaracterized. First, this assessment is inherently factual and requires an expert's specialized insight or a jury's balanced evaluation. Entrusting judges or opposing counsel with the sole power to determine a mischaracterization risks subjective or biased decision-making, inadvertently shutting the courthouse door to valid claims. If courts allow defendants, or even judges, to define what counts as a mischaracterization, it creates a dangerous precedent that effectively renders the plaintiff's own creative intent irrelevant. This results in a near impossible standard for plaintiffs to overcome, as key questions about the character's essence and unique traits would be decided without the guidance of an impartial fact-finder. Ultimately, leaving these detailed fact-based inquiries to expert testimony and jury deliberation upholds fairness in copyright litigation and protects authors' rights.
Before you wrap up, can you address the Metcalf point? And even if you have unpredictable elements, if they're arranged in a certain way that creates a substantial similarity, is there a triable question as to that issue? Yeah, no, there is not. First, I go note for the record that Appellant in her opening brief does not argue that the district court misapplied the test. She argues that the court neglected the test, which obviously isn't true because the order granting summary judgment tribal issue of fact because, as the district court had noted throughout its opinion, the alleged similarities, even in undetectable elements, were based on mischaracterizations of one work or the other. In fact, the entire comparison analysis was plagued with mischaracterization. And it correctly concluded that the selection and arrangement of these unprotected elements in no way approached the level of similarity present in Metcalf. I will add that in Metcalf, this court found each major extrinsic element in the allegedly infringing work to be substantially paralleling the allegedly infringed work, and it found that the similarities in the selection and arrangement of these unprotected elements was striking. I would submit that there is no such similarity in the unprotected elements in this case, much less a striking similarity between the selection and arrangement of those elements. I see I have finished my time. If you all have any questions, I'm happy to answer them. Otherwise, thank you for listening. No other questions. Thank you, counsel.
A reasonable juror could examine the following list and decide whether it is close enough to the same order and arrangement to pass the Metcalf test. Remember that each description occurs at the beginning, middle, and end of both, in almost the same order, despite one being a 2-hour stage play and the other an 8-episode TV series. In the beginning of both shows, a lean, wiry, shy, new girl carrying a vintage red suitcase arrives by public transportation. She checks into a seedy motel and needs to find work, so she heads to an erotic dance club to audition for talent night. The new girl is a mediocre dancer but hired on the spot. She is not dressed appropriately. The gender-fluid owner points her to a rack, where another employee hands her a skimpy outfit. The modest erotic dancer changes in the bathroom. Other dancers taunt her. The new girl keeps a secret life back home and doesn't disclose her true self initially. The owner is looking for a replacement for a veteran dancer who will no longer work at the club. The owner, who usually dresses as a woman, dresses as a man for a very important business meeting discussing his club's fate. The owner then tells the staff that things must change to keep the business afloat and explains that he is cracking down on employees. An employee lies about why she is late, but the owner comforts her instead of firing her. Love at first sight between a handsome young bartender and starlet as they bond over grandparents in the stockroom. The owner learns antagonist is plotting a takeover of the building so he can have the valuable land for casino development. The following descriptions occur in the middle of both SKC and P Valley. The owner is verbally assaulted and called a he-she freak by antagonist due to his lifestyle choices. The owner has had to endure homophobia and down-low relationships all his life. The antagonist hires an inside man to help with the club casino takeover. The inside man is reluctant and falls in love with club employee. Each dancer goes through individual crisis fighting poverty while caring for young children. A dancer L decides to leave the club to open a new business. A dancer attends church, paying tithes to heal from demons created by strained relationships with religious parents. New lovers fall out of love because of a gun incident. The owner brings the staff together in a huddle to announce the closing and last night at the club. The owner tells each employee how important they have been to the club. The owner reminds them that this is not the end, but the new beginning. The mood is somber yet positive. The following list of descriptions occurs at the end of both Soul Kittens Cabaret and P Valley. The ex-husband of one of the dancers comes to the club and grabs a co-worker by the neck. Gunfire ensues, and everyone thinks the owner was hit. People dress up for a funeral, but instead of a funeral for the owner, it's for the closing of the club. The entire staff and community are present. The antagonist shows up wearing a fedora and carrying a flask to taunt the owner and his employees after they lost the club. A female employee that no one liked was working undercover and saved the day, ends up owning the club. They celebrate that the owner can continue his business of running an erotic club. The estate of Paul Zindel sued Fox Searchlight and director Guillermo del Toro, alleging The Shape of Water infringed on Zindel's play Let Me Hear You Whisper. A district court dismissed the case, ruling there was no substantial similarity. Former Ninth Circuit Judge Alex Kaczynski then joined the Zindel estate and successfully appealed. Take a look at his closing argument, which mirrors that of the plaintiff in this case.
Dismissal of a complaint for lack of substantial similarity before any discovery is virtually unheard of. Indeed, this court has never affirmed the dismissal of a case alleging infringement of a literary work without discovery in a published opinion. That's not me speaking. This is from a concurrence in a decision by this court last year, reversing the very same district judge who dismissed the case here. It suggests why it is not only unwise, but even a denial of due process to deny a plaintiff the opportunity to present evidence. You know, it used to be that this court said rarely grant summary judgment, even wasn't even thought of. The idea that you would dismiss without a chance to put on evidence, without a chance to examine the defendants about what it is they in fact took, without putting in experts, in a way it's a denial of due process. This looks to me like the heart of the story was taken by The Shape of Water. I would think that they would want to clear that up. With so much commentary about it, with Oscars having been given, having been nominated for an Oscar for a Best Original Play, not adapted play, original script rather, I would think that they would want to have a chance to say, no, we didn't sit there with that script and steal the best parts of it. I would think that they would relish the thought of going before a jury, telling their stories, and hoping to be vindicated and basically clear their Oscars of disdain.
The Ninth Circuit reversed the dismissal, emphasizing that determining substantial similarity is fact-intensive and should not be decided prematurely. The case was remanded for further proceedings, ultimately underscoring that copyright disputes involving creative works often require expert or jury evaluations rather than early dismissal.
We can add 2 minutes for rebuttal. Let me jump right into this. There's much talk about mischaracterization, which is really kind of hard to hear because it's just untrue. And you have to look no further than the record itself. Let's take that bathroom example where counsel said that we mischaracterized the record, and so did the district court. Go ahead and look at 2ER-171 and 2ER-216. If we're parsing out whether the characters were modest and shy about their bodies, then that's the reason for them going to the bathroom to change in the back quarters of a strip club. Look for yourself. But this tripartite disagreement between appellees, and the district court that crystallizes how we have differing interpretations of what both works meant at the time. That is the province of the jury that the district court in this case violated. Okay? Let me speak to the expert issue. We cited a law review that was an empirical study on substantial similarity analyses, and it says it is folly to expect judges to be familiar with and understand the nuances of any given field, including those such as literature, that we often falsely imply are not as complicated as computer software architecture or others. Look at the Hanagami case. This is the Judge Wilson case that was reversed by Judge Pays just a month before our case was rendered. In Hanagami, Judge Wilson gave short shrift to the complexity of the dance and also to the length of the work at issue relative to the work as a whole. The Ninth Circuit reversed and said that's not the analysis. You have to look further at the elements just because it's too short and too simple in your mind. That's a judgment call. This is something where expert testimony might be helpful. And that's what the district court said. When I was growing up listening to rap music, my parents would say, why are you listening to that? Every song sounds the exact same thing. And I would retort to my dad and say, well, all the country music you listen to sounds exactly the same. And his response would be something along the lines of, well, are you talking about country or are you talking about western? And this goes to show that you just viewing things from a wide circle and not being familiar with the works themselves. I think district courts and Judge Wilson in particular in this case assumed too much to think that he had the requisite expertise to view the substantial similarity in this analysis. I don't think Judge as an expert in the music strip club genre. I'm certainly not. But Robert Half had reviewed several works, went through every single one of the Ninth Circuit's elements of substantial similarity and found that they were indeed substantially similar. Again, I can't entirely doubt that in the Ninth Circuit, substantial similarity in summary judgment is very narrow. The balls and strikes need to go to the non-movement. The district court didn't do that here. He went out of his way to find in favor of the movement with the preconceived notion that there was no substantial similarity. Further, just for the same reason, sorry to wrap up, sure, for this is the last one I'll make. For the same reason that in the Ninth Circuit said just listing a bunch of random similarities should be discounted, so too should be the list of dissimilarities. I can count 1,000 dissimilarities between the works. That doesn't mean that both works aren't substantially similar. Look at the Ninth Circuit's case in Alfred. It noted that the script versus the movie, there are striking differences, and there might be here too. That doesn't mean that they are not substantially similar for purposes of copyright infringement in the Ninth Circuit. Thank you, Your Honor.
Counsel, thank you both. Very helpful arguments. The matter will stand submitted. Court is adjourned.
This court for this session stands adjourned.
10 days later, on December 16th, just 9 days before the Christmas holiday, the panel affirmed the district court's summary judgment motion, ruling her case would not proceed to trial.
In addition to questions of due process, this ruling by the appeals court conflicts with recent rulings concerning expert testimony, which means this could signal the need for more clarity with the court. Appellant Nicole Gilbert Daniels seeks a rehearing en banc to address critical misapplications of copyright law by the district court and a Ninth Circuit panel. Specifically, the case raises 4 essential issues. The standard for evaluating substantial similarity, particularly the misapplication of the Metcalfe precedent. The necessity and admissibility of expert testimony in determining substantial similarity. The appropriate level of judicial analysis in copyright cases on summary judgment. Proper procedural standards for summary judgment, including viewing facts favorably to the non-movement. The case involves alleged copyright infringement between Gilbert Daniels' Soul Kittens Cabaret and the television show P-Valley. Despite similarities in characters, themes, and plot elements, the lower courts ruled in favor of the appellees on summary judgment.
This case is ripe for rehearing en banc for the following reasons. To ensure uniformity in copyright law, the panel's decision deviates from binding precedent Metcalfe, misinterpreting the substantial similarity standard by requiring a stricter, strikingly similar threshold. This sets a problematic precedent that undermines the protection of creative works. To emphasize the role of expert testimony. The exclusion of expert testimony contradicts Ninth Circuit precedents that recognize its importance in analyzing complex creative expressions, such as screenplays and film works. To clarify summary judgment standards, courts must refrain from removing fact-intensive questions, such as substantial similarity, from the jury's purview. Misapplication of these standards erodes plaintiffs' ability to seek redress for valid copyright claims. To highlight the broader implications for copyright holders, the panel's ruling risks creating an overly narrow interpretation of protectable expression, potentially making it nearly impossible for copyright holders to prevail in infringement cases involving derivative or complex works.
It's clear that both NiCCI and her legal team remained committed to her cause and how her story might shed light on the challenges independent creators face. NiCCI is seeking a few high-profile amicus briefs to support her fight, which she plans to take to the Supreme Court. That concludes our WRF TV special report on the high-stakes litigation of independent creator NiCCI Gilbert Daniels versus entertainment giant Lionsgate.
NiCCI is currently appealing the six-figure judgment that Judge Stephen Wilson imposed, an amount judges typically reserve for cases deemed frivolous.
While many disagree with that assessment, the harsh financial penalty serves as a stark warning. Underfunded plaintiffs should brace themselves for potentially devastating losses when seeking their day in court against powerful defendants. For Worth News, I'm Clarence Mack.
I am Helen McDuffie.
Thank you for watching Worth News, news worth sharing.
All right, beautiful people. All right, beautiful people. Your girl is back in full effect. I'm still off camera, but I just want to first say shout out to my incredible team. I want to send a nice big round of applause to my team. I'm sorry, my sound effects are muted. Hold on, we're going to unmute those. There we go. I am so grateful. Let me turn this down. I'm so grateful for my people. I'm so grateful for y'all showing up. I'm so grateful for you guys paying attention to this. I know it's not the most compelling, entertaining thing that you've ever seen. And I know many of you are probably really tired of me talking about this sugar honey iced tea, but I realize that this is just a really important moment in time, especially when we understand that the creator economy is $250 billion, you guys. We're going to talk about that tonight on the live show where I will be on camera at 10:30, 11-ish. You know, I want to give my West Coast people time to get ready and get sided and whatnot. But yeah, you guys, I wanted to run that and just have you see just the facts as they have been up until this point. Have you experienced, you know, some of you watched my case happen. And for those of you who did, I want to say thank you so much. That appeals court hearing was tough. It was very difficult. And 10 days later, the appeals court upheld the district court's decision. So we're in the Supreme Court, you guys. And what we're in the Supreme Court asking them is really plain and really simple. Do underfunded plaintiffs stand a chance when it comes to fighting for your intellectual property rights? Y'all, we're going to unpack this some more on tonight's live show. But I want to share this clip. And what's really important for you guys to recognize about this clip is this is the clip that Diddy's trial team did for the press after his trial. And it's really interesting what their perspective is. And just FYI, the second to the last attorney, the last woman speaking, is the partner to Katori Hall's attorney. So she works at the same firm as Katori Hall's attorney. And this is a small boutique firm, very powerful. You know, I love the fact that they're women. Don't love the fact that I'm going up against them. But just listen to what these attorneys have to say about due process. All right, take a look.
Today's a great victory. It's a great victory for Sean Combs. It's a great victory for the jury system. You saw that the Southern District of New York prosecutors came at him with all that they had. They're not stopping, but one thing stands between all of us and a prison, and that is a jury of 12 citizens. And we had a wonderful jury. They listened to every word, and they got the situation right, or certainly right enough.
Kim, I want to thank the jury for putting such great care into this case. They came early every single day, and I want to thank them, as I said in my opening, standing between all of us and the drastic consequences of the criminal convictions of sex trafficking, and RICO is a jury of our peers.
Thankfully, in our country, we have a right to a jury trial. And thankfully, Mr. Combs took that right. He actually battled for his freedom, for his innocence. He did it.
I feel like there's not a lot more that I can say because of these wonderful people have really said all there is to say, but I do want to thank Sean for the privilege of this opportunity to help him clear his name after all, with the Southern District coming after him, guns blazing. It really is a testament to the fact that when you get a fair trial and a jury of your peers listens to the evidence, they will do the right thing. And I just want to say again how proud I am to be part of it.
And this is Katori Hall's attorney's partner speaking.
And so I want to again thank Mark, Tenny, and the rest of these wonderful lawyers behind us. They did a fantastic job. And like those before me have said, our system, the jury system, is important. We need good people to serve on juries. We need good people to come and say a person is not guilty. Take that courage to do that. It's okay. We want you to serve on juries. This particular jury was a special jury. It was fantastic. It listened. It paid attention. It put the nonsense to the side. It put the distraction to the side and came to a lawfully good, just conclusion. Juries are important. Juries are important.
I don't know if you guys can hear me or not, but that is a good question. Is there going to be the first ever pro se petitioner granted the opportunity to have a jury trial, granted the opportunity to go before the highest court in the land? Will you listen to creative voices like me? And if the Supreme Court grants Gilbert Daniels versus Lionsgate, it will be an unprecedented moment in history. And the bottom line is, all you have to do is ask yourself, do creatives deserve a jury? Will justice finally listen? When 99% of all the petitions that come through are denied, when 99% of all of the copyright infringement cases that come through are denied, there is something going on in the system, you guys. Whether it's me or some of these big cases that I've heard are coming behind me, 99% plaintiffs lose. And that is a very sad and very slim and very terrible statistic. But we are going to pray that the Supreme Court of the United States, who met in a private conference room, my case was on the table. Ironically, it was the same day that Ghislaine Maxwell's case was presented to them as well. I will be heartbroken if they deny mine and grant hers. But hey, this is, the reason why we're here, because we know that the system needs reform. I hope you really got something from watching the AI breakdown of my P-Valley appeal. The full appeal is available if you go to the Ninth Circuit's YouTube channel and research or Google Gilbert Daniels versus Lionsgate. Tonight, I'm going to take a little bit of a departure on our live show. I'll be live at 10:30 tonight. So guys, make sure you guys come back. Yes, I will show my face. You will see me tonight live because we got some Q&As, and hopefully you guys watch this and you'll be able to, ask some questions or whatever. So please make sure you go to WIRF.TV.com. I'm sorry, WIRFTV.com, WIRFTV.com. You hit like, you hit share, you hit subscribe. You guys, again, I ask, will the SCOTUS make history with Gilbert Daniels versus Lionsgate? We are going to find out on Monday. They published their orders at 9:30, so we will know Monday at 9:30 if that is even a possibility. But I want to leave you guys with this message. I have a perspective on all of this. No matter what happens on that day, the truth is in the Supreme Court. And I went, you guys. I did it. As a Black woman, underfunded plaintiff, I lost my sister to brain cancer in March 23rd of this year. So many other things have happened, but we did not let that stop us. As a family, we just dug deep. I'm so grateful for my husband. I'm so grateful for my entire family, all of my small circle. And baby, it's been small and mighty because folks are not really doing what I'm doing. And when you do what I do, you find out who your people are, who your tribe is. And I appreciate you guys for being here and being a part of that tribe. Big things popping. But here's a message I want to share with you guys from my time in DC. And please make sure that you come back when you see me go live tonight at 10:30, because we're going to have our usual nights with Nikki. I can't wait to see y'all and for y'all to see me. But in the meantime, check out this message. Well, guys, the trip to DC has come to an end. And I am headed home. I am so grateful for this experience. Super grateful for this experience. It's been very enlightening and inspiring. Definitely. Super inspiring. So, Jesus, it is the ugliest bug ever. Hoping they one of them kissing bugs. Yeah, it's been an awesome trip. I feel inspired. I'm built for it. So today, the Supreme Court made a decision. I don't know what time they went into their conference, but they made a decision. So I'm hoping that the decision is that I get a chance to go forward. That's what I'm praying for, but who knows? All I can say is that I'm grateful. I'm grateful for my sorority and having the opportunity to advocate, even though a lot of the senators were not available for us to talk to. It was still a really great experience to walk the halls. And, we talked to their staff and told them what our mission was, which is to get them to co-sponsor this bill. I was on the partnerships for healthy partnerships for survivors act. And I shared my story, my mom's story. My mother is a survivor of childhood sexual assault. And it was wonderful to be able to be there and be present and be able to share my mom's story. So super grateful for that. Now it's back to work. I'm motivated. I'm inspired. I am, ready, It's a certain amount of relief that comes along with knowing that it's over, right? It's crazy because it's over. Or, well, we don't know if it's over. It is in the hands of the justices, and today they made a decision as to whether or not it'll be over or if I will have an opportunity to go before them in a hearing. And I hope that they allow me to go forward, but bottom line is, came all the way. So yeah, I got butterflies, but I'm gonna have them until next Monday when those orders come out. So yeah, that's it, you guys. That's it. Oh boy, here we go. Your girl went to the Supreme Court of the United States of America. She sure did. Cheers to that. Oh, and you know what? Own it. Oh, and Black Women Lead. Oh, and prettypoodles.com. You know what I'm saying. But yeah, it's been a great trip. I'm really grateful. Let me show y'all my view. I got a beautiful view. Y'all want to see this fabulous view? Look at that. Yes. Amazing. So, yeah, I'm grateful. Grateful to be here. Grateful to have had the opportunity to go before or have my case at least considered by the Supreme Court of the United States. I'm proud of myself. Super proud of me. Oh, yeah. Was that the bug? Oh, my God. I hope I didn't touch the bug. I touched something. Anywho. Ooh, maybe that was a bug. It's fine. Anyway, guys, I'm going to catch my flight, but I wanted to come see the water. Thank you, Jesus. Thank you, God. Thank you, Lord. Thank you, Mama. Thank you, Debbie. And thank each and every one of y'all, because your encouragement means more than you know. Look at this city. It was a great city. Crowded as hell. Y'all know I almost hit somebody on a bike today? It wouldn't have been my fault, because I was driving, doing the right thing, and he was riding a bike, doing the wrong thing, not paying attention. And thank God I had that Motor City swerve action, or else, oh boy, would have been splattered. And the car behind me looked like, when he passed, like, whew. I'm like, yeah, God was with both of us today. Because even though it wouldn't have been my fault, I wouldn't have recovered from that. So maybe my blessing will be that I get that Supreme Court decision in my favor. I wish the court could have seen me saving that kid's life on that bike, not paying attention, running out in front of my car. Do I get points for that? Can I get my writ of certiorari granted just because I did not run over the kid who had his headphones on, not paying attention, riding full speed in a bike? Probably not, but anywho. All right, guys. Go down and get a little closer to the water in a minute.